It's I take much pleasure in following the Dennis Denito of the National Party. For anyone who's ever had the pleasure of seeing The Castle, a wonderful Australian comedy, that wasn't a compliment. Mr. Speaker, sometimes this Parliament really is a bleak house. It really is a bleak house, and it's most often a bleak house when we turn our clocks back 200 years, as we are doing now, and going back to Dickensian traditions. Dickensian traditions that are born of a judicial system in the United Kingdom that doesn't allow solicitors to appear as barristers in the higher courts. And that is what this tradition arose from, and why it was right to be tossed into the bin of irrelevancy a couple of years ago. Do you know, Mr. Speaker, provincial areas have very few Queen's Counsel, but they've got a lot of good lawyers. And I'm a lawyer. I used to practice in Dunedin, and I know that the leading lawyers down there, the best advocates, were both barristers and solicitors. These were leading counsel. I'll just name a few of them. They happen all to be men because of virtue of their age. The people that were ahead of me in the legal profession were in the senior positions were men as a consequence of it being a very male-dominated provisions in those times. But people like Neville Markay, Bruce Robertson, Calvin Marks, who was the leading counsel and who was the counsel in civil aviation in Mackenzie, which was the case that distinguished between absolute liability and strict liability, and he was a barrister and solicitor in Dunedin, should have been made a Queen's Counsel, could never be, because he acted as a barrister and solicitor, because in provincial towns you actually don't have the wealth that's available to be spent by the government departments and the major corporates that you have in Auckland and Wellington to support a separate bar. Mr. Speaker, the best advocates in the provinces are generally found in, or often found, not always, but often found in the firms of barristers and solicitors. Alf Jevons is another one. Jim Guthrie is another man that comes to mind. But then if that's not good enough example, think of our current Supreme Court. Our current Supreme Court, our leading jurist, Justice Tipping, would never have been a Queen's Counsel. He's one of our leading judges in New Zealand, and no one would dispute that. He was a partner of Wynne Williams. He could never have been a Queen's Counsel, but he should have been able to be made a senior counsel. Is that an exception? No, it's not. How about Bruce Robertson on the Court of Appeal? Another leading jurist in New Zealand, was always a barrister and solicitor in a firm rather than a barrister sole, could never be made a Queen's Counsel, should have been made a senior counsel. You think, oh, well, that's only a couple. Well, what about Justice McGrath? Justice McGrath is another of our Supreme Court justices. Could never have been made a Queen's Counsel. He's on our Supreme Court. Before that, was the Solicitor General. But he was a Crown solicitor in the leading Crown solicitor firm in Dunedin. Could never be made a Queen's Counsel. What about our leading prosecutors in Auckland and Meredith Connell? They can never be made a Queen's Counsel. And you think, oh well, that's only a few examples. So I thought, well, what about Justice Blanchard? Well, he's another of our most leading jurists in New Zealand, and he could never have been made a Queen's Counsel because he practiced as a barrister and solicitor too, not a barrister sole. And that's what makes this such an absurd law. I feel like I should be here with my fingerless gloves, sort of in a black suit. No doubt they'll want everyone to have to put on their wigs again when they go to court. I saw an article about that in the paper. Here we go, heading back. Hair shirt said, no, they don't like hair shirts. They actually like silk. They like silk. Mr. Speaker, this is a nonsense. Now, they're making an exception for people who, during this period when we have had the ability to appoint senior counsel, they can continue. So they've got an exception for Jack Hodder, and I don't know how many other people were made senior counsel like Jack Hodder, and so they should, because he's one of the most capable senior court advocates in the country as well. This is absurd, absurd law. Mr. Speaker, what have other countries done? That might be illustrative. Are we following the trend here, or are we lurching to the past on our own? Well, Australia, as my colleague Charles Chauvel has already said, except for one state, they've all moved to senior counsel rather than QCs. Canada's done away with Queen's Counsel completely. They see that as an irrelevance. It's an old-fashioned concept that's done its time. And so have most of the other countries of the Commonwealth. Mr. Speaker, this is an absurd change. It is not bound out of principle. As I said, I don't mind the status that attaches to senior people in a profession. Whether it's scientists being appointed to the Royal Society or senior lawyers being made senior counsel, I actually think recognition of excellence is a good thing. I believe that. I just don't think that you should make artificial distinctions that aren't on the basis of quality. They're on the basis of some strange historical tradition inherited from the UK that has no relevance to New Zealand. I agree that we should celebrate our senior counsel. I agree that we should do that. I just don't think we should artificially exclude those people that I've listed who came from firms of barristers and solicitors on some spurious basis. It's as if those people are inferior if they're in a firm of barristers and solicitors and they have somehow some lower standards of ethics. What a nonsense. If they had any lower standard of ethic, they would be up before the disciplinary tribunal for breaching their duties to their clients. In fact, the fact that these people aren't proves that they're not doing anything wrong. So this is just an absolute nonsense. I cannot bring myself to vote for this bill, even though the second part of the bill is reasonably sensible, as others have already said. Mr. Speaker, I don't think there's much more to add, really. I think the arguments in respect of this are pretty simple. I do think that Nathan Guy's been sort of handed a bit of a hospital pass here because the attorney doesn't want to have to come down in here and argue the case for it. He obviously likes the name Queen's Counsel instead of Senior Counsel, and I don't have anything particularly against that other than it's an anachronism. The more important point of principle for me is this ridiculous return to the general position that what are currently called Senior Counsel, soon to be called again Queen's Counsel, can only be appointed if they're barristers sole rather than in legal firms where they practice in a partnership with barristers and solicitors. Sorry, I didn't hear the...
Move a supplementary order paper.
Oh, move a supplementary order paper. Well, actually, we'll do that, and I invite you to vote for it because it is an absurd... maybe reason will prevail on the other side of the House, having heard the superior contributions from this side and with that piece of arrogance, I probably would be entitled to be appointed a QC, but not a senior counsel. So, Mr. Speaker, I would have to decline on that basis, of course. So, Mr. Speaker, I won't say anything more. I think the arguments have been well traversed by Charles Chauvel.
I call Kennedy Graham.